Well, thank you for being here. This is a wonderful turnout. I'm glad that this many people are concerned about this topic or just want extra credit for their classes. Either way is good. We are also live streaming to Antelope Valley, so I would like to welcome the Antelope Valley campus as well for those of you who are viewing from there. My name is Lindsay Nelson. I'm a lecturer for the Department of Criminal Justice here at California State University, Bakersfield. The department, the Antelope Valley Criminal Justice Club, and the Criminal Justice Club on the Bakersfield campus are very pleased to host this event for you all pertaining to cash bail in California. I also want to give a special thanks to our department coordinator, Jenna Lords, for all of her hard work in making this happen. Yeah, I know, I would give her a round of applause. She really did put a lot of effort into this, and we appreciate her. So, as some of you know, some of you may not know, SB 10 was signed into law by Governor Brown August 28th, and it actually takes effect October 1st, 2019, which is less than a year from now. Prior to this law being signed in, individuals could be released from custody if they were able to pay their full bail amount or if they were able to pay a non-refundable 10% fee to a bail bond agent. Now, California has decided that they're going to get rid of this cash bail system with this SB 10, and we are now going to use risk assessment tools to determine individuals' risk of either committing a new crime or not showing up for their court date. Supporters of this bill are in favor of the fact that we will not be discriminating based on income, and they also like the fact that it could end abuse from unregulated bail bond agents. Opponents of this bill are concerned for the substantial loss of jobs in the bail industry. And they are also worried that the assessment algorithms could offer the judges too much discrimination to hold people in custody for preventive detention, thus perpetuating racial discrimination. So here to discuss this pressing issue, we have quite the panel that I'm excited to introduce to you. First, here to my right, we have Dr. Anthony Flores. He is an assistant professor for the Criminal Justice Department here at California State University, Bakersfield. To his right, we have Scott Spielman. He is our assistant district attorney. To his right, we have T.R. Miracle, and he is the chief of probation here in Kern County. To his right, we have Glenn Ace Pierce, and he is with Gotta Go Bail Bonds. And then, last but not least, we have Kyle Humphreys, who is a local defense attorney here in town. Okay? And also asking the questions of this panel, we have our own Dr. Callie McCullough, who is an assistant professor for the Criminal Justice Department here at California State University. So I will give it up to Callie for the questions.
Awesome. Thank you, Lindsay. And thank you, panel, for coming and spending some time with us on a Thursday evening. So I would like to direct my first question to Chief of Probation, Chief Miracle. How will this bill affect the operations of your agency?
A lot.
Yes.
In reading the bill, obviously, it's interesting because nowhere in the bill does it say probation. But the way it's worded, it's pretty clear that probation is most likely going to be the department that's going to handle this, kind of be in charge of the new apparatus, at least on the front end. And so done a lot of research about how it will go, and operationally for our department, we feel we'd probably have to hire at least 30 additional staff, probably at a cost of $3.5 to $4 million. And that's just a guesstimate until we get in there. We won't know exactly. So obviously that would affect a large impact. Probation is used to a lot of new reforms, though, with AB 109 and many others. We've expanded before and be able to try to take on something that's new as far as the reforms. I don't know if you want me to talk about the actual process itself and how it would go, but that's basically how it would affect us. We'd have to hire significant more staff, train, obviously work closely with the courts and the jails in order to accomplish what the bill asked us to do.
Okay, great. Thank you. So increasing your staff by 30 members, and it might cost millions of dollars in those changes. So thank you. So next, Defense Attorney Kyle Humphrey. This question will be directed your way. According to SB 10, additional duties will be imposed on county public defenders due to the requirement that a preventive detention hearing commence within 3 days of the prosecutor's motion. So you are a private defense attorney, but hopefully you can shed some light on the effect for public defenders. So,
I did have an opportunity to speak to Ms. Singh, the Kern County Public Defender. She anticipates, of course, needing more staff, more expenses. It will be difficult because the turnaround time from the defense side is shorter. The prosecution and law enforcement can make immediate arrests. They can wait and fully investigate cases, make later arrests. They can issue warrants of arrest and move at a slower pace and be ready to justify a position or a request for preventative detention. On the defense side, you're going to get discovery dumped on you. You're going to have very little time between the time of which an arraignment takes place to actually read, prepare, and respond. So it's going to put the defense at, I believe, an extreme disadvantage. And there is the likelihood that even more resources will be needed because many of the proprietary risk assessment tools will have to be challenged on constitutional grounds by public defenders' offices and by private counsel, because we won't know exactly what's in those tools and what is keeping our clients locked up, even though they're presumed innocent.
excellent. So related to that concern about the risk assessment tools, I would like to now ask Dr. Flores. So SB 10 ambiguously defines what constitutes low, medium, and high risk levels. And the risk is pertaining to if you will commit a new crime or if you will be showing up to your court date. So that's the risk that we're assessing. So what factors are measured in our validated risk assessment tools?
So within the primary risk assessment tools that are available for pretrial, I think that it's worthy of note, at least initially, to point out that within risk assessment for reoffending, so like post-conviction, right, rather than pre-conviction, there's considerable existing research, and many, including myself, feel very comfortable, if not confident, in the ability of a number of risk factors to differentiate those who will recidivate from those who won't. Those types of factors, again, for post-disposition, include the way that people tend to think about crime, personality, impulsiveness, things of that nature. The list continues, but specific to pretrial, I think a discussion of those risk factors should start with the acknowledgement that research is very much in its infancy, right? So there are identified factors, and there are at least a few fairly rigorous studies that have identified these factors, but across the board, those studies blatantly make a call for more research, more rigorous research kind of thing. But of the two kind of primary or dominant pretrial risk assessment instruments that exist, you have one from the federal level, that is the PITRA, or the PTRA, and they're really kind of static or unchanging types of items, kind of historical items. So criminal history, of course, right, like what you've done yesterday, it's a good indicator of what you'll do today kind of thing. The current offense, age, educational attainment, employment status, it's almost kind of a stake in conformity kind of variable. Residential ownership, that's unique to the federal pretrial risk assessment tool. And then substance use problems. And then the last one, and again, I think this is a function of being used at the federal level, right? So by federal probation. But that one, and it's unique to that federal tool, and that one's citizenship status in that case. And then the other major tool that was developed by the Arnold Foundation taps into similar risk factors, getting at criminal history, getting at employment, and also including within that age, again, the current offense, the current pending charge, previous failures to appear. So again, tell me what you did yesterday and I'll tell you what you're going to do today kind of factor. Prior convictions, prior violent convictions, and then prior incarceration. And so across the board within all of those, the theme is historical factors, not really kind of current more treatment-directed problems, but things that have happened in the past, behavioral history in essence, in large part anyway. Thank you.
Thank you. Okay, so now I'd like to ask a question of Scott Spielman, the Assistant District Attorney. So the bill states that prosecutors are required to give notice about the arraignment to victims so the victims can be heard on the matter of the accused's custody status. What additional duties will be imposed upon your agency in regards to victims, but also beyond the victim notification?
So like everybody else, we're going to need more resources. If we're going to be they're going to require us to do something that we don't currently do, certainly not on a majority of the cases. There are in Kern County filed every year approximately 6,000 to 7,000 felony cases. So when the chief here says that he needs 30 more people to do this, that's the reason why. Every single one of these cases is going to need this evaluation done. And then we're going to be in the same boat as the defense attorney in trying to represent our side at this 2-day hearing that we don't currently do. We don't even show up at most arraignments. We don't have enough people. The court usually sets, the way that it's set up right now is that before this law is actually implemented, right now there's a bail schedule. So when somebody commits a crime, over the years they have developed a bail schedule that says a person accused of this crime, this is where we're going to set this bail. And it evolved over years. Every year they would evaluate it and determine if it needed to be changed. That's the way the system is right now. Now they're going to look at the individual. They're going to do a 2-day evaluation that's what his department's going to do. And they're going to look completely at the background of the offender. They're going to look at the crime that was committed, brief that, and then what you're asking about is we have then an obligation to contact the victim if there's a victim on the crime, whether it's a property crime, so let's say it's a residential burglary, or it's a assault, some type of an assault. Then we're going to need to contact the victim, find out if they have anything that they want to express at this hearing that's going to be 2 days after the arrest. And so that's going to require people to try to make that contact, find out what they want to say, and then we will be having attorneys making appearances at these hearings. And so that's going to require some additional resources on our part also. And we don't do that currently, so we would need some additional revenue to be able to do that.
Excellent. Oh, yes, please.
Can I chime in briefly?
Yes.
So in response to what you were saying and then to what you were just saying now, I don't know if you made it clear already, but it was my impression that there would be a standalone office that would just deal with the assessments, or is that going to fall on probation? Or
The way it's written is basically probation has the kind of the right of first refusal of who's going to do the pretrial assessments. Mm-hmm. And if probation declined to do it, then the county can create, it can't be an existing agency, they could create a brand new agency that would do it. My guess is that's not probably going to happen anywhere. Mm-hmm. My guess is probation is going to do it everywhere. My bosses are the judge. I'm appointed by the judges, so if the judges want me to do it, I'm going to do it. So in most counties, I think that's what's going to happen. And so probation will be the ones who most likely will be doing the assessments in every county.
Gotcha. And then I think just kind of a comment, but I think that paired with a number of times when you were just speaking kind of the stressing of 2 days, and I feel for you within that. That's an awfully quick turnaround time on getting an assessment done.
Yes, so I would love to expound upon this time constraint that has been put on your departments and your agencies. So just to inform you all if you haven't read the bill, so I would like to ask about the risk assessment process. The bill says the risk assessment should be completed within 12 to 36 hours, depending on the type of crime and circumstances. So I would like to ask you all, anybody can chime in that would like to talk about this, but what does the risk assessment process look like in practice? And is that 12 to 36 hour time frame reasonable?
We're going to have to do it, so I've read a little bit about it. So basically, for most misdemeanors, except for some carved out exceptions, there won't be an assessment. They'll be released. And then on the felony cases, we actually have 24 hours to do our assessment, and then it gives you an extra 12 hours if there's good cause. they don't explain exactly what that is. But so basically it's 24 hours for us to do the assessment. We don't know what tool we're going to use yet. The Judicial Council will have to come up with a list of what they deem as suitable assessment tools. So each tool is a little different, but we'll have to be housed, our officers will have to be housed in the jail because we have to have contact with the defendants. So we'll do an interview. A lot of it, like Dr. Flores was talking about, our static criminal history things. So we'll have to be running a rap sheet, getting all that information, and then feed it into the assessment. The assessment will give us a score, and then based on that score, the legislation says some different things. So first, there's several carve-outs that no matter what the score is, you're going to be detained. So certain violent offenses, or depending on if you are already on a supervision felony status, you're going to be detained no matter what, but we still have to do the assessment. Let's say you don't have any of those exceptions, then if you come out as a low risk, the presumption is that you're going to be released. You can be released on your own recognizance with certain conditions. If you're a high, you're going to be detained until you go to your arraignment and then go before the judge. And then if you're a moderate, the legislation calls for basically local rules. So every county will get together, led by the court and the stakeholders, and come up kind of what the rules are. So basically you're going to have different situations where you might detain some of these, you might release some, or you'll make recommendations to the court. So we'll have to get that. And then what we do, if it's a low, we assess them, they would be released right there. If it's somebody who's detained, we would then have to do a report to the court, which basically has the score, a recommendation by us that if they are released, what type of conditions they should have on them, and then any supplemental information that we have, we would submit that to the court, and then the court, with the attorneys on either side arguing one way or the other, would have to make the decision.
Can you give us some insight into what you think the potential decision will be on those moderate risk? It's probably going to depend partly on the judge it's in front of. I mean, you have different things. I mean, in general, we're a more conservative county than others in California, so it's, but it's really hard to say until we get into the process of exactly what it's going to go. But, there is a lot of pressure now on the judge that they're going to be the ones in all these cases making the final decision of this person getting out or are they staying in. So it'll definitely be interesting. Yes, for sure. Interesting.
I think to chime in with there,
Yes,
and
please.
largely I think it'll depend on what the cutoffs developed will look like in terms of low risk or moderate risk or high risk. But in existing studies looking at that, a very large percent falls in that moderate category, unfortunately, kind of thing. So it's even additional burden-wise. But yeah.
So kind of piggybacking off of that, Attorney Humphrey, if you could please tell us what you think, how this will affect the clients that you serve, particularly in the case if they're deemed to be a moderate risk, and how you'll present that case or your side of the case to the court.
I think you have to start by acknowledging that nothing changes. These risk assessment tools, you're talking about historical data. If you're in a conservative county, you're likelier to have a record of something that may disqualify you from getting out because they're over-aggressive in prosecution. If you're a person of color or a person from a lower socioeconomic group, you automatically are going to have those historical qualifiers because of over-enforcement in those communities. So you're basically continuing the same ideas that led to the decision to try and get rid of cash bail. And it's not something where someone came along and said, this is how we want it to work. But if you're basing it on this historical perspective, that's how it works. So we need a change in that, and these risk assessment tools, if they're historical, are not going to change that. If you look at people and say, we're going to judge you by what you did in the past, but when you're 18, you miss 3 traffic court appearances and have failures to appear, and you're 22 and you get involved in something maybe a little heavier or you're accused of it, remember, these people are not guilty. They're presumed innocent. But you get arrested, those factors can keep you from being out, and they're going to drive more social unrest and social problems because people are going to lose their jobs, they're going to lose their apartments, they're going to have nothing. When you're at the lowest levels of the economy, and you can't afford to miss 2 days of work because you can't make your rent, 2 days waiting to get assessed can cost you everything. From my perspective, presenting what I can for these clients, it's going to have to require reaching into the minds of these judges to get them to understand, just because you're in a conservative county and you're an elected official, it's not just to imprison people because of fear of re-election or because that's what your people say they want. You know, this idea that you get to claim because you're in a smaller community that you're more conservative and harder on crime is really a shifting of the social cost, burdening the rest of the state or burdening the school systems. And I don't know how you begin to get the judges and the people in charge to look at that so that we start treating people more fairly. I think from my perspective personally, if I could get to the very basic thing that has to be understood is that most people are good. And these system that we're talking about presumes that most people are bad. So we have to get people and show them what's good about our clients and get them to understand that this historical data, maybe that's a reflection on the ceilings that person had in their life. If you're raised by people that didn't have jobs, so you've never had good employment, it's not been modeled to you, you've not had that opportunity, why should you sit in jail for a moderate crime when you're not guilty, when you haven't been proven guilty beyond a reasonable doubt? So I think it's just going to be a lot more people sitting in jail, a lot more crowding of our jails.
So on the flip side, Assistant District Attorney Spielman, so how could this bill affect the way you are filing charges?
Yeah, I'm with the Dark Empire from what he's talking about. We're not going to solve everything in a bail hearing, by the way. What it comes down to, in the past, or the system we have right now, it looked at two things. It looked at dangerousness and looked at flight risk. Those are the two primary things that we looked at. This new law kind of looks at that, and understand this, nobody likes this new law. The people on the far left don't like this new law, because most likely there will be more people incarcerated awaiting trial than there are under their current system. On the other side of it, if you want to look at the prosecution side of it, we want the judges to take a look at the criminal history of a person, about whether they failed to appear. Because here's the reality of it. This is a law that came up that only, I think, sounded good to politicians. They're the only ones that were smiling when it was signed. It just doesn't work. It tries to address a lot of things that in the end, the judge is going to be too worried about letting people out. In New Jersey, they had a similar bail reform that was done. And in a case back there in October of last year, there was a guy arrested for domestic violence. And then he got released under their bail reform and didn't have to post bail, got released, qualified for it. Then in December of last year, got rearrested on a new case involving weapons at a daycare that he wasn't supposed to be at, that still involved the domestic violence situation, and got released again. Then in February is when he killed her. And they named the judge in that case, and you can bet that that judge, if that's an elected position, it's back in New Jersey, I don't know how they do their judges back there, if they are appointed for a long period or if they have elections periodically. But you can bet somebody's going to run against that judge and probably oust him. That's going to be the fear of the judge, because I told you, there's about 6,000 to 7,000 felonies every year filed in Kern County. So a judge is going to be making decisions on those felonies that will come back to that judge if that person goes out and does something bad while they are released. So that's the reason that the advocates for bail reform don't like this law, and it makes sense to me. In 2 days, we're going to try to figure out all the dangers. And the reality that we have currently is we will probably go to what the misdemeanor arraignment is like now. About a third show up. That is the reality. These There are lots of different reasons that people find themselves in the criminal justice system, all right? I'm not going to try to address that. That's what you can look behind it and try to figure out what's going on and with the history and presently, you know, what are incarceration rates, all those things. That work needs to be done. The reality, though, is that when people are charged with misdemeanors in our county, they are almost always released pending the arraignment because we just don't have the resources to keep people that are in on a $5,000 bail. They don't have to post that bail on a misdemeanor. They get cited and released because there just isn't enough room in the jail. So then they're supposed to show up at an arraignment. 1/3 shows up. I heard somebody describe it that I think is accurate. The people that show up are volunteers because it tends to be people that they have responsibilities or they have jobs. Let's say it's a DUI, and they have to show up. They can't have a failure to appear on their record because no one is going to go look for them. There are tens of thousands of warrants out there right now for people that have failed to appear. Over the years, they've accumulated. Nobody is out there looking for them. What tends to happen is that they will run across law enforcement again. They'll get picked up on something else. They'll see that they have a warrant. They'll be actually booked on that warrant, and then guess what happens? They get released again. Sometimes it can happen up to 10 times before finally the judge says, okay, that's it. You're just not abiding by what we're telling you. Then they'll do a no bail. But that's the reality. And the fear that I have working this system is that that's what the felony system is going to go to if you have too many people being released on essentially their own recognizance, because cash bail is going to be gone. So when a person has a warrant on a felony right now, the bail bonds people are going to go find them because we don't have the resources. Law enforcement doesn't have the resources to go out and find very many of these people that fail to appear. That's the value in over the history of bail, why it was enacted. Then they have the motivation to go get them and bring them back. That's the reason that the bail system came about in the first place. So I'm not saying that there isn't necessary for reform. You should always be looking to improve something, especially if you can demonstrate that it's unfair. You should always be looking to improve it, but this is a horrible solution by everybody's opinion in the system.
Aren't there, in this case, and I think you were even mentioning some of the disqualifying criteria, so like in the case of the domestic violence example, wouldn't that person be disqualified from receiving release?
When they wrote this law, they already knew about this case in New Jersey. So like most laws, it's reactionary. So by golly, they put those in there. There's 4 different domestic violence aspects of disqualifying.
Protective orders and similar, right?
Yeah, because that was the first thing I thought was protective orders. Okay, you can say that it's domestic violence, but you know, there's a lot more violations of restraining orders that come across our desk. Because I told you there's about 6,000 to 7,000 felonies. In our county every year, there's about 22,000 misdemeanor cases that get filed throughout our county. So you're talking about processing lots of cases. Our system it sure isn't perfect, but it is as efficient as I think it can be made with the resources that we have, that we work under. And this is going to be an additional burden. But yeah, they've tailored the law, but that's the reason why, you know, I don't think that they had a very realistic understanding of what we look at in our system day to day. Most of the people that are coming across on the felonies, they do have extensive criminal records. You know, some of it may be misdemeanors, some of it may be felonies. But understand this, that the lower felony cases, with the changes in the law recently that essentially made all possession of drugs misdemeanors, no longer felonies, they raised the limit for grand theft to $950 from $400. All of those very low felony offenses are gone. And so now you're left with more serious of crimes. And so the people that are committing these crimes, they tend to more likely to have a criminal history. And so as they're looking at those factors of what kind of criminal history do they have? Are they currently on probation? Are they on post-release supervision? Have they had failures to appear before? Somebody that has a lengthy criminal record, you can bet they have failures to appear, at least on the misdemeanor cases. And so that's the problem, is that the exceptions swallow the rule. That's why the people that are the advocates for bail reform recognize the dangers that not only Do you have a judge that's going to be very cautious about releasing somebody because that can come back and bite them? But all the disqualifications that they have put into this new law is going to end up probably locking up more people awaiting their trial. And it's not that they're not guilty, it's that they're presumed innocent. We'd still have to prove that they're guilty. And if you wonder why does it take so long to get cases to trial, that's a legitimate question. The fact of the matter is that if you were arrested today and you were going to be going to and you wanted to go to trial as soon as possible, then on a felony, then we have to get you to trial within about like 90 days. But the reality is that cases need to be prepared by the defense, and nobody is in a big rush to get to trial. But if you wanted to get to trial, I really can't do much to stop that within 90 days. But there's reasons why it continues. So that's what some people don't understand that.
If I could bounce off of Scott a little bit too, one of the reasons this new idea is just horrible for anyone accused, we already know that being locked up is a coercive factor in plea bargaining, especially at the lower end. If you're sitting inside, you're going to lose your job, your wife's going to leave you, you might miss out on some opportunity. You're more likely to say, well, I'll just plead guilty. Even on some felonies, people are anxious to plead out because they have other things that they believe are more important, and they don't really understand the lifetime negative consequences of a felony conviction. Under this new law, with more and more people, which, I've read the positions of the ACLU and the original backers, who've all withdrawn support for this attempt at reform. And the reality is, we're going to have whole classes of people, because of charging decisions, because of definitions that pre-exist this law, that are not going to get out. And they'll want to go to trial. But even if they're innocent, everybody in jail knows about the trial tax. It's an inherent flaw in our system. People get more time if they go to trial and lose. So less than 5% of cases really go to trial. So you're going to have a lot more people that are innocent pleading and going and doing time. And that's going to happen because they have these broad definitions in this law, such as a crime of violence. What does that mean? And then they have exclusions that are morals types clauses, certain types of sex offenses. Well, which ones? And what if there's good, solid evidence that perhaps a person is not guilty? The case will still go through the process, but you're creating presumptions that are rebuttable, but you'll never get to the facts because you won't be able to produce evidence of having the witness come and be cross-examined in front of a judge at a bail hearing. I don't see that ever happening. So you're going to see a lot more people locked up, a lot more people not necessarily forced, but in a coercive environment, making plea bargains, and we're going to keep our jails filled, unfortunately, with more innocent people without resources.
Okay, I'd like to bring Glenn in on this conversation. So this question is for you, Glenn. So in eliminating cash bail, it's estimated that roughly 3,000 people in the bail industry will be out of work. How do you see this bill affecting your business, and what are your plans for the future?
Well, there's actually about 3,500 bail agents in California. That doesn't include the staff. You put about another 3,000 on that would be out of work. I've already took another business on. I'm a private investigator now because of SB 10.
Okay, great. And do you have any other friends in the bail industry? What are they doing?
A lot of people are just retiring. A lot of the older people are just shutting their doors.
Was it just kind of offhand, I guess, but have you heard of any talk of bail bonds agents looking to like relocate to other states, or is there kind of the assumption that it's already populated with bail bond agents.
A lot of states, you have to be a resident for 2 years before you can get a license.
Gotcha. And then I could see potentially if this sweeps across other states, you'd run into the same issue kind of thing.
Yeah, it's everywhere.
Thank you. So this question will be open for anyone who wants to answer. I'm going to talk about a little more statistics that we haven't really touched on yet. So the estimated number of individuals detained in California jails who are only there because they could not afford to pay bail ranges from 7,000 to 28,000 individuals. So research shows that African American and Hispanic defendants are more likely to be detained pretrial, and that being detained pretrial can increase the likelihood of receiving a longer sentence. So this information brings me to my question. How likely is it that I'd like to get all of your opinions, how likely is it that this bill will have a reverse intended effect and will actually keep more individuals, particularly minorities, held in jail?
Good.
Okay, so is it a unanimous agreement across the panel?
Oh, absolutely. It's again, you're going to take people with historical assessments, the disadvantaged, people of color, people who are from communities that are higher crime. You're going to take those people and they're going to be disqualified and they're going to be sitting inside. So nothing is changing about the institutional bias. We're just now saying that we're doing away with cash bail, and by the way, you should feel good about that, and you're presumed to be dangerous. So it's not going to change anything.
I would just add that the bill does address this to an extent, and a lot of the rules that are going to be made are Judicial Council is going to have a panel of experts. It's a panel of 7 at least, 4 of which are experts in assessment, and one of those experts at least has to be an expert in implicit bias in assessments. It also calls for collection of data that will be through the BSCC, and which will evaluate the impact by race, ethnicity, gender, and income. So I think the authors of the bill certainly realize the concerns that are being expressed here, and I think there's certain assessments that probably show more of a bias than others, and when they create that list, they would, I assume, would be trying to pick the least biased assessment there is. So I'm not for or against this bill per se, but to say that there's bias in this process, therefore we shouldn't do it, but then we're left with the current system, which you would also say there's bias. So sometimes I think you got to take a baby step to get somewhere. And then, like I said, I don't know if this is the right way to do it, but I think it is recognized, those issues, and whether they be addressed or not, they're at least looking at it, and I think would attempt to as it goes forward.
Which is great as long as you don't get arrested until they figured out the bias.
It probably would have been a better idea to figure this out before you enacted the law, rather than, well, let's enact the law and just kind of see how it goes. You know, that I don't think is generally a good idea. And so that's the reason why it's, you know, you have you have both sides. It's an adversarial system. And so when Mr. Humphrey goes to court, we've had cases together. He's arguing the best interest of his client. I'm arguing on the prosecution side of things, but, you know, everybody kind of agrees on this one, that this is just a bad idea. So it would have been nice if they would have figured this out ahead of time. And that's kind of like New Jersey, they've had it enacted, I think, for about a year or two. And they're kind of doing the same thing. You know, they have their own horror stories about things that bad have happened and people have been released. And then it's well, let's take a look at it and see how it's going. Well, why didn't you take a look at it before you enacted it? That would have been a better idea.
So if they do find in their data collection and reports and investigations of the consequences, if they do find some severe bias, what do you think would be the next step? Would we revert back to a bail system or try to continue with the change system?
The problem is that's trying to solve something that is much bigger than just bail. You know, if you want to look to, you know, systemically, what are the root causes of these problems, you're still, when you're just trying to decide whether or not to release somebody who is accused of committing a crime, you're almost always going to look at, is it safe to release them, and are they going to be there for trial? And that's the reason that, it may have the same reflection that you have on the complaints are now, or about the incarceration rates right now. So I don't think that that's probably going to change. That's why it's probably not going to change. And so, if you're trying to really solve that, I don't think this is going to do it.
I think that within all of this, and particularly this concern over bias, which is a very legitimate concern within that, this is an awfully academic point, and so acknowledging that at the outset. But I think a positive in this is that delivering this risk assessment and having a measure of dangerousness that's validated, that's objective, or at least more objective than what we currently use, that's standardized, so we're looking at the same factors across whoever's doing the assessment, that gives us a measure at least to go on, so a year later or two later we can look back, and now we have a valid measure, a reliable measure of if there is disproportionate denial of bail or denial of release or granting of release. And so I think that's a positive within that. I have certainly had issues with this, but I think that's an important step in moving forward with bail reform. Without that measure, we have nothing, right? We don't know if somebody was dangerous or not. Their current committing offense is not an incredibly strong predictor of what someone's going to do in the future. We tend to, it just kind of feels good at our core that, the felon is more dangerous than the misdemeanant, but that's just not supported research-wise. So there's a positive in administering a measure such as that. But that said, there are other issues that I would have with that, and I understand that's kind of an academic point for wanting to look into the data and see what's there, but still I think it's worthy of note. Without that, we can never move forward and learn, right, and get better at what we do. Certainly I understand the point that I don't know that we want to learn and get better at the potential risk of public safety. I acknowledge that, but there's a positive in that regard.
I think you might be onto something, but unfortunately, we do things out of habit, and all of our institutions are habitual creatures. And really, even the idea of a bail schedule that the judges are supposed to create, there's no science to it. Nobody has ever actually figured out what bail should be. And so bail, if you start with the idea that something we label as a bad crime gets a high bail, every other crime gets a corresponding bail in relationship to that, you're still going to end up with a racial impact and an economic impact on people without money, because that bail amount has nothing to do with their ability to pay or whether they'll show up in court. And Mr. Spielman's right. Because of overcrowding of the jail and the lack of willingness really to intervene and attempt to keep people out of crime with our mass incarceration system, everybody that gets a misdemeanor, by and large, just gets a citation now. So that's not the problem. But part of the problem that drove this bad solution was that you did have a bail system that for years was just made up. The numbers were made up. So getting academia involved to really look through social science at what factors we could use to set bail, I think could help make cash bail work again.
Thank you. For the defendants who, in your experience, were granted bail, what was the typical range of the cash bail?
It depended on what the crime was.
Yeah.
No, it was, if it was a first time, even on a more serious felony, it tended to be about $20,000 to $50,000. I would say.
A good example for that, and this is why one of the problems with bail is the soup du jour is domestic violence. And we've kind of recognized after massive destruction of generations of our population with the war on drugs, we're not doing that so much anymore. So the money is shifted under the VAWA Act, so domestic violence is the thing now. The bail is $50,000. That's just arbitrarily made up. That's the bail. And everyone has to post that because law enforcement has to make a felony arrest. If it doesn't happen in their presence, you have to make the felony arrest. The bail's $50,000. That's out of reach for most people. Even though the DA's office knows that not every domestic violence situation is a felony and files a large percentage of those as misdemeanors. But people end up getting locked up, when their bail's reduced, still at $5,000, they may not get out because they didn't have that opportunity to cite.
And Glenn, could you expound on that, what the typical process was for someone, let's say, who had a $50,000 bail and they came to you? How would that work?
Well, it would depend, several things. If they're a union member, they would get a discount. If they're a military member, they would get a discount. A homeowner, over the age of 55, they get discounts. If they're gonna hire a private attorney, they get a discount. And I'm one of the guys in town that takes a lot less down and sets up a payment plan with them. But what you see here is you see stacking of bail. So if they're arrested for a gun charge and the gun has 10 bullets, you see an officer book them for 10 bullets, which is a separate bond for each one. So that bail would be normally about $130,000. Where you can go over to the next county, Tulare County, and they don't stack bail. Whatever the highest bail is, that's what they do.
Now, they're talking about, so when they get arrested, there's different times that bail is set. So when somebody is arrested and they're booked, that's the first time that bail is set. So they haven't even been in front of a judge yet. But that's what he was talking about, what Mr. Humphrey is talking about, is that there's a bail schedule that the jail follows that is set. So if they're booked on these particular charges, that's what bail is going to be set, that they can actually make that bail and get out before the arraignment, before the judge, which is supposed to be within 2 days if they stayed in custody. Then when they go in front of the judge, then the judge sets the bail depending on what charges are ultimately filed. So if their original bail, they were arrested on a felony spousal abuse, if it's filed then as a misdemeanor case, which is, it happens a lot, then it would tend to be reduced down. And so that's why it does change over time. And if you were to ask me what's a better idea than this, it is you would need to spend more resources on it because you'd need to provide for the defense to be able to appear at bail hearings. Because if somebody feels that their bail is unreasonably high, they can petition the judge now to have the bail reduced. So the system is not so inflexible that it doesn't allow that. If somebody feels that and Mr. Humphreys brought these motions before, feels that the bail is too high, they can appear before the judge and make their case as to why it is. This person doesn't have much of a criminal record, if any at all. They're not a flight risk because they have ties to the community, significant ties to the community. The crime is not so serious that there's a danger to the public in releasing this person awaiting trial. Those are the types of arguments that are made right now. If that were enabled to be done on more cases earlier in the process, then those people that should be let out at a lower bail would have that opportunity. But it's hard for the defense, especially public defenders, because they have huge caseloads, to be able to do that very often. So if you're asking me a way to change the system now, that would be one way of doing it. You're still looking at the same things that this law looks at. It's just that you're doing it in a more controlled environment, that you have time to actually be able to make the presentation to the judge that's not within 12 hours of trying to figure it out and then give it to the judge and make a decision like that. You know, that's why judges are going to be very cautious about approving people for bail, that they're not sure everything that's going on, or they feel that it's going to come back and bite them. There was a misdemeanor case here a couple of years ago that a man pled to a second-time DUI. It was a typical plea to it. The guy was out on bail as it was, and the only thing that the defense asked for was to put off sentencing for a couple of weeks. Not unheard of. The judge approved it and allowed the guy to stay out on custody to clear some things up before he was going to be going in for a short period into jail. During that time, he committed another offense, and the media jumped all over it because you don't usually report when somebody just simply does their job, because that's boring. But if somebody, it's more salacious when this person was released on bail. Well, if he hadn't pled, he'd still have been on bail anyways. If they just continued the case and waited to plead, have him plead for 2 weeks. So nothing that was done was unusual in how we handle cases. But you can bet that judge was named, and it came across very poorly for the judge. And it really was unfair because it wasn't anything unusual that happened. And the person was already out anyways. But it sounded good to put it out there in the way that they put it out there. And I didn't think it was really fair on the judge.
And I think Lindsay mentioned it in the beginning. One of the concerns that led to the passage of SB 10 was about predatory bail practices. And if, Glenn, you could chime in on this, or ADA Spielman or Attorney Humphreys, if you have any story where you've seen this happening, where somebody has been preyed upon by a bail agency.
What I've seen is bail agencies take little or no money down, and then when they don't get their payments, they use jail as a debtor's jail, which is illegal to do.
And I can tell you, working with Glenn over the years, he's one of the few bondsmen that I'm willing to work with. I've never had a problem with the way he treats clients, but the bond is supposed to be valid for a year. And one of the practices is, let's say that the case needs to be filed at a certain court appearance date. The DA's office doesn't get the paperwork from the police. The case gets filed later. Your client goes to court. There's no court date. A warrant issues that he's already posted the bond on. And some of these bail bondsmen tell them you have to post a whole new bond for $100,000 or $50,000. And the legitimate guys have them come in and say, well, it's like $35 for me to get this through the Department of Insurance again, and I'll go post your bond again. But that's one of the ways they do it. And then another way that I've seen is that they don't tell clients that on particular crimes that are likely to have a lower bail 2 days later when they get to court, they don't mention that. And so they make a windfall profit. It's unfair.
I think the abuses that they're talking about there is something that, with more regulation, dictating how that business is operated probably could solve that type of problem. Because we've had that where there is something that's delaying an investigation for one reason or another, and so we are not filing the case immediately. And then, we're not trying to put them into a position that they're going to lose that bond, but we try to do it timely. It's just that we might not be able to do it, and then I don't see why that they would necessarily be punished financially because you assume a bond and then reassume the bond, and all of a sudden are having to pay twice the amount that you normally would. That doesn't make really sense to me, but I think that could be handled through just a different regulation on it.
The other one that I've seen that it comes from the desperation to be out. And so far we haven't really talked about liberty. Liberty seems to be unimportant in a lot of the discussions that we have, how precious it is, how our country is founded on its protection. But you get people who are fearful and desperate, and some bondsmen will get 5 or 6 or 7 people in a family to sign away their property, to agree to come in at a certain time every week with wages, and there's no way that they can sustain those payments, and they ended up losing sometimes their houses. And the truth is, it was people who really couldn't qualify to pay the bail.
Similar to that, and in that stream of bail thinking, I guess I would say, but do any of you have any ideas on how a cash bail system could be made more equitable across social class? So I think that's kind of a driving force behind all of this, right, is the inequality and essentially the detention of lower class. So how could a system that continues down that road ever get over that inequality?
I think you need to start with the idea that bail should have some correlation to making you go to court, or a legitimate correlation to protecting the public. I mean, we just made up a bunch of numbers, and over time the numbers kept going up, and the have-nots couldn't pay, and so they got incarcerated. And unfortunately, because we set all of this process in motion on historical data, well-to-do people who commit a serious crime don't have that historical data that says they're not going to show up or they're likely to commit another crime. So you need to really look at, in the beginning, how many of these cases could we legitimately just OR if we took the time to get people hooked up with social services, to get them hooked up with existing agencies, to get them to court. I mean, in some counties in other states, they're actually sending text messages to defendants on misdemeanors so that they know about their court date. You're talking about people without jobs, without opportunities. You know, your doctor's office tells you when to come in. I mean, those simple things can happen where it could be more equitable. I don't know that it would work on the more serious crimes, because I think you really have to assess the person. And I actually believe that we have, you know, we're looking at what, 70% of the people sitting in jail in Kern County right now are not convicted. I think we could have a lot more people out and really target the dangerous people if we took the time to do it, not just labeling everyone as dangerous.
It was an assembly bill that was designed to try to reform bail before SB 10. And a lot of it kind of followed what you're talking about. And it talked about really what are the assets of the person that's accused of the crime? What are they able to afford to post for bail? And they kind of looked at it that same way. Problem with that, though, is that you're still having to do this same analysis in 2 days to try to figure out not just what's their criminal background, what's the criminal offense, what's the offense here, but what's essentially what's their assets, what's their social status kind of thing. And that's going to be even more costly. And
Just have them bring pay stubs to jail with them, right? No problem.
That's usually not a lot of pay stubs with most people in jail. However, it tried to address these things, and including actually calling contacting the person to remind them to show up for the arraignment. You know, that's a nice thought, but remember, we're talking about almost 30,000 criminal cases in our county alone. And we are one of 58 counties across the state that you're going to be trying to pay to modify a system that, if you're going to be doing all of those things, then you're talking billions added to budgets that are already underfunded, really. And so I think that's the problem with it. There was like I said, an assembly bill that tried to address these things, but those are the type of problems that they ran across, and it really, especially to crime victims, we're talking about the accused here, which, you know, we're talking about bail. That's the main focus here. However, imagine your loved one is a victim of a crime, even a residential burglary, and you find out that they are releasing the person that is charged with committing the crime on basically a promise to appear. You know, what do we think that people that tend to do burglaries, thefts, they tend to be drug addicts, they tend to continue to steal. We had a case, I just saw a case that I dealt with that it's a guy that he's got something wrong with him. When he gets out, he tries to kiss women and grope them. Not in a felony level way, but in a misdemeanor level way. He's on his 3rd case now that he still is awaiting to be arraigned on his previous 2, because that is the misdemeanor system. They keep getting released on these promises to appear, and he actually shows up. He's one of the few that actually did show up, but he gets released and he does it again. And so when we're talking about somebody that they're a drug addict or they have mental illness, and we need to try to address that because that's a root cause of what is finding themselves in the criminal justice system, we have to have the control over them to make them have to show up and at least face the consequences that if you don't change your behavior, then you're going to continue to be incarcerated, you're going to continue to be in this justice system. But that was part of when we started a mental health court here. And that was right at the time, though, that they made all of the felony possessions of drugs misdemeanors. We actually lost an opportunity there to have a felony case on somebody that can ultimately be diverted, but we're making them have to deal with what brought them into the criminal justice system. And we don't have that ability now. And I'm not saying whether that's good or bad that that law changed. That's the reality of it. And so now, with people with mental illness, by the time we are able to actually address it, it's a felony. Because on misdemeanors, they're not going to do any type of mental health court. They're not going to do it because they're going to get out of jail and they know it. And so it takes them getting a felony case that essentially forces them to have to deal with it. And we lost that chance when they made a lot of those low-level felonies misdemeanors because they're just not going to do the programs. And so that's just the reality. Like I said, I'm not saying whether it was good or bad to change that. That was the reality of it. And so if it's a felony, now it's going to be a much more serious felony, and it's going to be much harder to deal with them in a diversionary manner.
So you briefly touched upon this topic. Our discussion so far has been mostly offender-focused. So I would like to ask, in your opinion, how will this bill affect the crime victims that you typically work with, whether it's in a positive or a negative fashion?
I think it's going to be frustrating to them because they're not going to understand it initially because most crime victims actually don't understand how the process works. And that's why we do have advocates in our office now that help them through it. They help them on violent crimes to try to get reimbursement for out-of-pocket losses for funeral expenses, medical bills, things like that. So we actually have some advocates now, but they're handling thousands of cases right now. And so this would be an additional task that we'd be assigning to them. I think initially that, like I described to you, if you're a victim of a crime and you find out that the person has been released just on a promise to appear, you might not be happy about that because we've seen the property crimes have been jumping up recently, and we've seen the violent crimes have been going up. I think that initially that it's going to be another frustration with a system that's already frustrating. It is going to add an additional burden to us to try to contact that victim within 48 hours to get their feeling on it, to let them know they have a right to be heard. And I think that most victims would hope that the system is going to work properly. It may not be perfect, but they're hoping at least to get some justice out of it. And so I think they're going to have that feeling that now they're not getting justice because it's a system that is letting somebody out who is accused of having committed a crime, and they're not getting any kind of redress from the justice system. So I think there'll be some frustration in it, understandably.
It would be interesting to see if you could compare how victims feel about the current cash bail system and how they feel after the change, because as some people are concerned, it might actually end up incarcerating more people as opposed to releasing more.
I think on that part, they'll probably like that.
Yes, so that might be a positive impact for
and understand that a lot of times the crimes, somebody in a lower socioeconomic class that is accused of a crime, if it is a crime involving a victim, the victim tends to be in that same class. And so it's, they may feel that they're not being addressed properly either. They may think that the system is unfairly discriminating against them too. So it's, like I said, I understand there's a lot of concerns with the system that need to be addressed, but I just don't see how this is really going to do that.
I think this is a very good step in the right direction. Again, I think in considering that the phrase "don't throw the baby out with the bathwater," right? There's a lot of negative to this in my view, and it seems as though in the rest of the panel's view. But again, I think the importance of having a research-based validated measure to identify different groups of offenders, or at least accused offenders, on a measure of risk, that's the only way that we can learn and move forward and get better and refine our predictive abilities, to learn more about who presents a risk and a danger to the community and who doesn't. Again, that said, I originally started with risk assessment in pretrial is awfully new in terms of how long that's really kind of been a sub-discipline within criminal justice and psychology and other social sciences. So that's primarily my concern there, but I don't know that my issues with this would lead me to argue getting away from this. I think that this can be improved and be better implemented, but getting away from this essentially leads us back to wholly discretionary decisions, right? It's just a crapshoot. Like, who are you going in front of? And it's entirely up to them. I understand that under this as well, judges still have discretion, but discretion considering this information. So I don't know. I'm not saying that I have an answer, but I see a lot of value in this. Again, admittedly, academically, right? And in the interest of knowledge accumulation and learning and getting better. I don't see an alternative, though. Abandoning this, I don't know how we would improve. We would just be making up decisions as we go. I don't know how we would get better.
Well, and the problem that I see is that you have this assessment that's being done, and the way that's structured right now, the way that we're anticipating here is you're going to have a small group that is in the low risk. You're going to have another somewhat small group that is a high risk, and then you're going to have this huge moderate or medium risk. That then you're left with the judge making that decision. And again, the system that we have right now, it looks at two things: the dangerousness and the likelihood of showing up for trial. And
but how is dangerousness defined currently?
Currently, it's going to look at the criminal history of the defendant. That's what this does. It's going to look at the crime committed here. That's what this does. And so ultimately, it is a judge that's going to make that decision. That this more clearly perhaps lays out some factors to consider.
Much more clearly, actually. But I'm with you on the discretion.
Yeah, but that's what the
I'm with you
judges
on
do
discretion.
already. They already do it. That's why I would prefer a system that enables the judge to have as much information as possible and allows the defense, especially again with the public defenders' caseloads that are huge, the ability to be able to articulate that in front of a judge in more than just 2 days.
I'm with you on the time frame as well. That's tough.
In response to your affection for this, Professor, I kind of look at this, and maybe it's an extreme worldview, but this seems to me somewhat like animal testing. We're going to torture you, we're going to deprive you of your family, your community, your liberty, which is probably more important than almost any other value competing interest. That's ultimately what we have, is our individual life protected by our constitution. Our Constitution is accused people facing the weight of the government. It may be interesting to gather academic information, but at what cost? And right now...
At the benefit of learning, though, right? The cost would be not doing it and not progressing.
I hope no one kidnaps my dog and
But how is somebody being tortured if you're making a discretionary decision versus a evidence-based decision? How is that torture?
Because you're
Wouldn't you rather
already-
someone be professional and have evidence to support their decision? I'm sorry to interrupt you. I'm sorry, go ahead.
No, that's okay. I mean, I get your passion, but I think when you talk about being evidence-based, it's not evidence-based. You're
It
saying
absolutely is.
we're going to go out and gather evidence.
It absolutely is. Just like insurance or anything else, right? You're looking at current offenders or current individuals and comparing them on characteristics of previous offenders or individuals and making a prediction, right? Making a probabilistic prediction. That's all it is. That's all prediction is, right? But absent that, I mean, 7. Right? You're just rolling the dice, right? There's no rhyme or reason to it.
We're already rolling the dice because if you categorize.
That's what I'm saying. You're right.
But under this system, it's going to be worse because you're going to categorize entire groups of crimes and say, that's no bail. You can't get out. And maybe because liberty is so important, the approach ought to be, what is the least restrictive means by which we keep the most people out, free to fight their cases, to work, to enjoy their liberty, and make sure that we actually are using the tools that are available to us to look for the people who are legitimate risk of serious reoffense. Yes, drug addicts tend to commit property crimes. They tend to keep committing those. Is the answer to go to the victims are upset, no bail status, or maybe the answer is to providing them with drugs? I mean, there are other answers out there where we're not taking liberty and we're addressing a social problem where we've destroyed families, created millions of at-risk children because they're not in a positive relationship with a family member. These things are not just confined to this small study of who did what crime. We have not invested in preventing crime. And that's something, the direction that we could go in that maybe is not so inherently mean-spirited.
Thank you for that. So in the interest of time, I'd like to, I think TR, looked like you wanted to make a comment, maybe the last comment on that, and then we could open it to the audience.
Yeah, in preparation for this, we had probation officers, had a judge, and some members of the Sheriff's Department go up to San Joaquin County, and they currently have a pretrial assessment program. Of course, it's different than would be under SB 10 because it goes parallel with the current bail system. And they use the Virginia tool. And so in looking at some of their numbers, we were talking about where will people fall into that. It looks about 24% would have, over the last several years, were low, about 63% were moderate, and about 13% were high in those numbers. And so that kind of just gives you an idea of, I would think we'd probably be similar in that aspect. But just to address, the way the law is written is certain things are excluded from being released in the initial judgment, but it doesn't mean that the judge doesn't have the discretion later to release, and there's opportunities along the way to revisit that. So although a certain list of offenses from probation's point of view, when you're first arrested, yeah, you can't get out. But along the way, just like it is now, where the judge can release someone on OR or they can reduce the bail, there would be opportunities to make those decisions. So all the arguments that defense could make now, they can still make. The only addition would be the judge would also have this evidence-based score as just another piece of his decision-making. It's very clear that the judge is not beholden to the assessment. That's just one additional aspect that he can consider in making his decision.
Thank you, panel. So with that, I'd like to open it up to the audience for audience questions. Okay, great, we have our first question.
Hi guys, I'm an MPA student and I'm actually working on 2 projects right now that involve SB 10 and implementing this in Kern County. And one of the questions I had for you guys is, I was curious what some of the factors are to ensure a successful pretrial services department. If you guys have to create that department, what are you going to need in order to make sure that that's successful other than just having the tool implemented and money? What kind of training and stuff like that needs to be done with your staff to prepare them?
Money is the first thing, but you already mentioned that. But we're going to have to, first of all, you have to pick what tool you're going to use, and we have to wait for the Judicial Council to get that selection. we would have to then, look at it with internal stakeholders of what tool we felt was the most appropriate. There would definitely be the process of we'd have to hire all these new staff. So, and that, as you know, in the county, that takes a long time. That's a long process. And then, of course, to train, and of course, it's going to be new, so there's going to be bumps along the road. Going to other places that have done it already, I think, is helpful. We've learned a lot by going and visiting other places and keeping a close contact with other departments and how they're implementing it. But some of it is when you have a criminal justice reform, it doesn't always go smoothly. When AB 109 came along, there's a lot of bumps in the road. But if it's the law, it's our job, whether we like it or not, to implement it to the best of our ability. And so we just have to push through and do as good as we could.
Hi. My question is how you're saying if the probation does take on SB 10, since you'll need more money, would that be like a budget cut for other departments, such as the sheriff's?
It's a really good question. And SB 10 is kind of unique because the bulk of the job duties is still a state mandate. The money flows through the state, through the courts, which is a state entity. So how it would work is the state would give money to the courts, and the courts would then pass that on to the probation departments. So in that sense, you never know, but I have some confidence that we would get the money we would need. However, what Mr. Humphreys and Mr. Spielman have talked about with the addition resources needed for public defenders and prosecutors, that is not covered. That is a county mandate. And so there's a process if the state passes a law that creates a new mandate, that the state has to pay for that. But that's often, if it's not, it's often a long process because you have to go through it and they have to show that, yes, this is a mandate and it's cost money. So it could be several years down the road before there's any actual implementation for that. For that, there could be where the county would have to come out of the coffers for some of those services, or they would have to go at least and make an argument before the board to say, hey, we need this additional money. But as far as for probation and the pretrial assessments and the monitoring of that money would come directly from the state.
That's why he likes it more, because he knows he's going to get paid. I think he's right. I think on the prosecution, on the defense side, it sounds like it's state mandated for like our obligation to inform victims, and then for the defense to represent the accused. But the way that you get that is that you do it and then you ask the state to pay for it. Well, when the state has lean budgetary time, sometimes they don't pay their bills. And so that's why it can be very difficult sometimes to recoup that money.
Hi. It sounds like there's great opportunity for things to get a lot worse before they could get better. What I'm wondering about is who's going to be doing the research so that there can be this data that goes back into the system to improve things. Is that funded? Where in the system does that happen? How quickly can that happen?
In the legislation, it does call for there to be collection. Like I said, the BSCC, the Board of State of Community Corrections, is to contract with a university or a research center to do that. And it does say there'll be funding, but there's no budget attached to it, so I don't know what that funding is. But they are supposed to evaluate the impact of race, ethnicity, gender, and income as far as that. However, that report would be several years in the future, so it wouldn't be automatic, would be well into the future. But they do acknowledge it, but I don't know if it's to a sufficient level or not.
Sorry, I had one more question. With all of the bail businesses that are losing business because of this, have there been any thoughts of potentially partnering with the people that used to run the bail businesses, since they have so much experience with releasing people, getting people who don't show up on that? Have there been any thoughts on that, maybe working with them and finding job opportunities for those people involving this?
I haven't heard of any yet. I don't know if you have. It's pretty recent. We're still, I think, kind of, our heads are spinning a little bit. So as we go forward, I'm sure we'll look at all the different stakeholders we can to see, what the best way going forward would be.
I have, actually, Antelope Valley has sent me 3 questions, so 2 of them are short. So I'll just read them and you can answer any of the ones that you would like. The first question they have is, on average, how many staff members will review the assessment before it gets finalized? And once an assessment is finalized, can that be appealed by the detainee? And then they want to know if any measures are being taken now to create additional space in jails for moderate risk and high risk offenders.
The first one, we don't know exactly, so we don't have the protocols set up, but I would imagine we would have our frontline staff doing the assessment, and it would pass through at least a supervisor in that initial 24 hours to make that determination. As far as what the recourse would be if they disagree with it, that's another question I'm not sure, because I'm sure the defense could bring up, and they could see, we would submit the assessment, so they could challenge one of the areas that, regarding their criminal history perhaps, that was erroneously mentioned or written down. So I would imagine there would be a process, but exactly what that would look like, I don't know. As far as the making more room, I think that's a little probably premature to figure out now as far as what the impact would be. Obviously, if there are more people held out, what's going to happen is you're going to have a Fed cap issue where if you reach your maximum capacity, you would have to then release people. So SB 10 doesn't take away any of the abilities for the sheriff to release and make those decisions. He still has that ability. So if the population did go up, he would have to have a release valve at some point. But to me, it's a little premature to figure out exactly what. I know in San Joaquin, which again is different because it's not SB 10, it's a bail, and their numbers actually went down, and they had a lot of positive things to say about it. But again, it's not going to be necessarily the same, situation.
Relatedly, what do you think the impact of this would be on the Community Corrections Partnership? Or has that become a significant part of that?
And for those who don't know, the Community Correction Partnership is the body that, the local body has district attorney, probation, sheriff, district attorney, public defender, and other departments, and they're the ones who decide how to deal with realignment and how to divide up the realignment money. So it's where we get together and have lots of discussions just about the criminal justice system in general. I don't see much of it, really. I mean, I'm sure everyone at the table would have an opinion on it one way or another, but the way that it's written, they really don't cross that I would see. So,
Did anyone else on the panel want to comment on that one?
Well, that particular board deals primarily with how to deal with somebody that's already been convicted in the system. And so that's where they've come up with some different alternatives to incarceration, be it supervision, placement, things like that. So that's the problem, is that this is pretrial.
I think when I was asking about the Community Corrections Partnership, I probably could have been more specific and just addressed Sheriff Youngblood, and just kind of what's his thoughts specifically and how it might impact his jail. Yeah.
Well, it's just about 7 o'clock, so if you could please join me in a round of applause for the panel. Thank you. And maybe if you had a question, they might stick around for a minute.